Chairman Thomas, Vice Chair Matthews, Ranking Member Isaacson, and members of the House Judiciary Committee, thank you for this opportunity to provide opponent testimony on House Bill 160. My name is Gary Daniels. I'm here representing the ACLU of Ohio. As this committee knows, Ohio voters across the state overwhelmingly passed Issue 2 in November 2023 by a 57 to 43% margin. On the evening Issue 2 passed, and continuing at least until today, opponents have theorized, speculated, and created out of thin air reasons why Ohioans so thoroughly approved of this change to Ohio law. Even though Issue 2 proceeded as an initiated statute, subject to changes by the General Assembly and not a constitutional amendment, those same voters can be forgiven if they assumed any changes by the legislature would be minimal and complementary to the overall goals of Issue 2. After all, because the Issue 2 campaign opted for the initiated statute route and process, that means the General Assembly had 4 entire months to make changes, tweak language, and work with that campaign on these matters before Issue 2 reached the ballot. In fact, as part of that process, legislators in the Issue 2 campaign could have reached agreement on these issues and possibly kept Issue 2 from even reaching the statewide ballot. Obviously, none of that happened, but here we are today nonetheless. Now, 1.5 years after Issue 2's passage, HB 160 imposes a litany of negative changes on cannabis users, consumers, growers, and professionals to dismantle key parts of current Ohio law enacted by your constituents. For the sake of brevity, I will focus on 2 topics in my testimony: changes to criminal laws made by House Bill 160 and the cynical scrapping of the Social Equity and Jobs Program. With regard to the criminal laws, HB 160 changes and creates various criminal offenses. At worst, these changes can be interpreted as purposeful, designed to kneecap Issue 2. At the least, these changes fundamentally handicap the purchase, use, transportation, and sale of cannabis in the state. Consider the following, and this is not an exhaustive list of these changes and our concerns. For an exhaustive and comprehensive list, I'd refer the committee to Karen O'Keefe from the Marijuana Policy Project's testimony, which I think does a much better job of outlining the entire list of these issues. But for, again, the sake of brevity, I'll mention a few. House Bill 160 makes a criminal out of someone who shares a joint with another or gives a small amount of cannabis as a birthday or Christmas or other type of gift. Of course, no such restrictions exist for alcohol. HB 160 outlaws traveling to another state and returning with cannabis bought there. But Ohioans can still return home from their favorite out-of-state microbrewery with a can, 6-pack, or entire keg of beer. HB 160 inserts law enforcement into landlord-tenant relationships by criminalizing violations of a lease agreement that prohibit cannabis use in or on rental properties. Despite Ohio's bursting and expensive jails, HB 160 imposes a mandatory 3-day jail sentence and a total possible 6 months in jail, plus a mandatory fine of $375 to $1,075, plus a mandatory suspension of a driver's license for various first-time violations involving a motor vehicle. To be clear, this section is so radically broad, it applies even to a passenger in the back seat of a non-moving car on private property. Repeat offenses result in mandatory minimum jail time of anywhere from 10 days to 5 years. It is also worth mentioning here HB 160, like current law, relies on an entirely inaccurate and outdated method for testing the impairment of suspected cannabis users. Current law also does not allow defendants to challenge in court their alleged impairment, but HB 160 doubles down on all this just the same. With regard to the Social Equity and Jobs Program, when they overwhelmingly passed Issue 2, Ohioans approved a comprehensive social equity and jobs program modeled on those existing in other states. The general idea is twofold. First, to ensure some, most affected by laws enforcing cannabis prohibition, receive some preferences and incentives to now benefit from the new legal status for cannabis. Second, to provide an ongoing stream of funding for such things as criminal legal system reform and expanding addiction services. HB 160 tosses this all overboard in favor of a system quickly devolving to favor those with the most resources and influence. When Issue 2 passed, there was hope among many employment and business opportunities for those who could benefit the most were not far behind. Instead, HB 160 appears designed to purposely shut them out. No one should be surprised if this trajectory accelerates in coming years. We ask that these concerns and the people they impact not be so callously tossed aside, and to restore the Social Equity and Jobs Program as Ohio voters intended. Clearly, there are some positive parts of House Bill 160, but they do not outweigh mandatory jail sentences, criminalizing behavior to make things worse than before Issue 2, gutting reform efforts and funding, and kicking to the curb those most impacted by Ohio's nonsensical, never-ending war on drugs. For these reasons and more, the ACLU of Ohio urges this committee's rejection of House Bill 160. Thank you, Mr. Chairman.
Sure. Thank you for your testimony. Are there any questions for the witness? Representative Callender with a question.
Thank you. And just for the record, I'll probably have a question for everybody, so add me to the list. Thank you for coming and testifying. Thank you for some very valid and important points. Appreciate that. You did mention that there are some elements of 160 that are acceptable and some that might even be needed. And I guess I'm going to ask that you keep an open mind, and if you could make a list of amendments or things that would make the bill a good bill, an acceptable bill in your mind, and narrow it down to those things. Because I think, I guess that's my question. Would you be willing to do that quickly here?
Yes, through the chair to Representative Callender, we can certainly do that. Again, our focus, just so the committee is clear, is not on sort of the industry concerns with Issue 2. Our focus is much more narrower on the criminal law parts and, again, the social equity part. So we will be happy to get to, if the chairman is willing, we can submit this to the chair for the rest of the committee and, as well to your office directly. More thought and language with regard to those types of changes. And we've also been working with an awful lot of other advocates here in Ohio and across the country, I think, as you well know, on House Bill 160. So we will also put our heads together with them, and perhaps it becomes a joint submission, but no pun intended, but, we will make sure to get you that information.
Great, thank you.
Mr. Chair. Thank you. I think, as I've said before, I think this bill represents the most thoughtful of the approaches we've seen from legislators. I think there are some things that everybody in this room on all sides agree we need to deal with. I'll bring out my exhibit a little bit later. And if we could find some common ground, I think the sponsor has mentioned that he wants to have a fairly stripped down bill and some of the other things we can deal with later. I want to address all of the advocates in the room, the pro-cannabis advocates, to work diligently to come up with ideas and amendments that allow a bill to go forward to address those issues that we all agree need to be addressed, while leaving the other stuff to address one at a time in later legislation to deal with each of the sub-issues later. So I appreciate your you and your well-funded organization helping with that. Thank you.
Thank you.
Would you like to comment?
No response. Thank you. Through the chair to the representative. Thank you.
Okay. Representative Williams with the question.
Thank you, Chairman. So I've had my own concerns about portions of the bill, and I've drafted amendments, and I'm working with the sponsor, so I would love to see what proposed amendments you have. But part of your testimony concentrated on the Social Equity and Jobs Program. So I'm going to ask this blanketly without you giving a broad definition. When you say in your testimony that it's supposed to help some people, right? How are we defining that? Like, what do we mean? What's the intention of what you envision a program that has not spent $1 of the tax money generated, because there's no clear guideline. It's a phantom program that doesn't have any direct outline of how we're supposed to respond to that as a state, how we're supposed to develop that program. So what do you see that program as, and what do you believe that some people in your testimony that you mentioned, what does that group look like?
Through the chair to Representative Williams, the reason, of course, for saying some is because, I didn't want to leave the impression that this would help all people, particularly those most impacted by cannabis prohibition. But, the idea, really was to say, we can help some people. We can create a framework. We can do it much in the way, even if it's not entirely perfect, of the language that was passed in issue 2. And I realize the ship has sailed, but again, I have to mention there were 4 months to do this before issue 2. There were no bills, no hearings, no nothing with regard to tackling issue 2 before it got on the ballot, or even saying, hey, legislators in that campaign, let's work together. So again, I realize that ship has sailed, but I think we can have a similar process where we assemble, hopefully, interested parties to talk about this a little bit more. If you have concerns, if other committee members or House members have concerns about the scope of that program and perhaps some of the language, but I think the overall intention of saying, now that this is legal, there should be incentives, there should be outreach, there should be what have you for those people who have suffered the most under prohibition to now be able to take advantage of the legalization of cannabis.
Follow up?
Follow up, yes.
You shouldn't give me a definition of who those people were. Let's be clear what the social equity and jobs program was intended to do. The underlying thesis was that black individuals were disproportionately affected by the criminalization of marijuana and cannabis in our state, and therefore they should have preferential treatment moving forward. You even used the word preference in your testimony. And we know from the Students for Fair Housing admissions case, the courts have clearly outlined that we're not going to be able to give race-based classifications, race-based preferences. We're not going to be able to use gender. We're not going to be able to use these classifications under the 14th Amendment. So I'm trying to understand how we're going to generate taxes and then give it out to groups by preferential treatment. I mean, that was the goal. Black representation in the cannabis industry was the open goal of issue 2. And that's unlawful. It's unconstitutional. So I'm trying to understand why we're trying to preserve a program that the state of Ohio cannot administer. We cannot use race.
Through the chair to Representative Williams, I see nothing in issue 2. I see nothing in the Ohio Revised Code that mentions race whatsoever. What it talks about and what we're talking about is people most directly impacted. Now, is there a disproportionate impact on black Ohioans with regard to cannabis prohibition? Of course there is. We have the data for that. ACLU of Ohio itself has issued those types of reports. But there's nothing, like I said, in current law or issue 2 that mentions race whatsoever. The byproduct of the war on drugs is that some people, including via race, are most impacted. But we're not talking about just race with regard to that.
Follow up?
Yes.
See, that's the problem with the program. It wasn't specific enough, right? We know what the intentions were because we saw the marketing that was around it. Right? We saw the marketing that was saying that there was underrepresentation of black individuals in the cannabis industry, and therefore we need this social equity and jobs program. We saw the marketing that happened under issue 2, but it's written so broadly that the state of Ohio can't administer it. So that tax money is just sitting there when it could be used for specific things like substance abuse treatment, reentry programs, things of that nature. That could be a positive benefit for the state of Ohio. So I'm trying to get an understanding of what the social equity and jobs program looks like. I asked for that specific definition from you, like what it looks like to the ACLU, and I don't get any specifics. I get a broad statement about policy that the state of Ohio can't implement.
Through the chair to Representative Williams, to be a little bit more specific, Ohio, of course, decriminalized cannabis to a large extent back in the 1970s, led by the Republicans. So what you don't have is the same horror stories that you hear in other states of prisons being packed with cannabis offenders. Nonetheless, you do have people who have lost jobs, who have spent some time in jail, because we did, at least at one point, we had cities that would have slightly, while it was a minor misdemeanor for possession up to 100 grams in Ohio, you did have some municipalities that said, well, we're going to elevate that under home rule at that point up to a full misdemeanor, not just a minor misdemeanor. So you did have people who were going to jail in certain municipalities around the state for that, people who have been denied professional licenses, people that haven't been able to enter various fields. But I doubt that this is something we're all going to hash out right here and now to everybody's satisfaction. And so if there's a larger conversation to come of this, certainly ACLU of Ohio, and I'm sure others, welcome that. What we don't think is that we should say, well, let's just scrap all of it and not try to figure this out whatsoever. So if there's more conversations and discussion forthcoming with regard to this, certainly we hope we're invited to the table.
Representative Timms with the question.
Thank you so much for testifying today about the bill. I also have an issue with the bill, mainly because of the social equity and jobs program. I think the voters were clear in issue 2. And so I think I'm cautiously optimistic. I choose to see the glass half full. I think there is a way to define how we interact with people who have been harmed by prohibition in a way to allow them to enter into the industry so that it's not, only utilized by the wealthy and out-of-state companies who come in and take advantage of people who would like to enter into the industry. How do we make sure, based on the language in this bill or an amendment to this bill, how do we ensure that the little guy gets to participate in the program?
Yeah, through the chair to Representative Timms, I think that was certainly a concern of Ohioans well before issue 2. I can't remember off the top of my head when legal cannabis was last on the ballot, 2016, 2018, something like that, before issue 2, and that was roundly rejected. And what a lot of people, what a lot of voters in Ohio were saying is, what this appears to be is an effort so that only very few benefit from this, and not other people in ways that Ohio voters thought they should benefit. So they roundly rejected that effort most recent before issue 2, but then very overwhelmingly approved this particular effort. And I know from our own organization, we had our organizers going out speaking to people around Ohio, speaking to them specifically about the social equity and jobs program, and I don't know how they would have voted otherwise. Perhaps they still would have voted for this, but there were a lot of people very much anticipating and excited about the social equity and jobs program in the hope that it would help maybe not even them, but some other people they thought were deserving of being able to benefit from the new status, legal status of cannabis.
Follow up.
Thank you, Chair. And so because of that, a lot of the work done on that campaign was juxtaposed against alcohol. And we've also heard, this committee have heard from small brewery owners, craft breweries. They're also fighting the big guy. And so do you think there are opportunities to align language so that the marijuana or the hemp growers can also benefit from programs that some of our craft breweries and small businesses across the state are able to take advantage of?
Through the chair to Representative Timms, indeed, and I think that's what was just sort of the most shocking part of this is that there appeared to be no effort to say, hey, even if we've got reservations about the social equity and jobs program, let's talk about this and see if we can find a way to do this, even if perhaps if it's a slightly different way or a different way to do this. But let's not just exit right out, no discussion, no debate or anything. We think it's worth preserving. Maybe, of course, in the grand scheme of legislative compromise, it's not 100% the same way as Ohio voters passed it. But we think that any changes, as I mentioned earlier in my testimony, should be complementary to issue 2 and the goals of issue 2. But it takes people sitting down and talking this stuff out. And House Bill 160, at least as currently written, doesn't allow for that. It just says we're going to scrap this all together. And the problem remains outside of House Bill 160, too. This is in the current budget bill as well as scrapping the social equity and jobs program.
Follow up. Representative Mohammed with a question.
Thank you very much, Mr. Chairman. Thank you, Mr. Daniels, for your testimony. I could not agree more. I think a lot of the provisions that you covered are not complementary. These are substantial changes to what the voters wanted. I did want to ask you one specifically regarding the landlord-tenant relationship and the criminal charges that would arise from that. It's my understanding that typically under current law, these are generally civil charges, civil cases, correct? These are not criminal. So what sort of an impact would it have for it to be criminalized under the?
Through the chair to Representative Mohammed, true, almost all landlord-tenant relationships or disagreements are civil in nature, not all of them, but most of them. And right now, quite frankly, the penalty for violation is a minor misdemeanor. In the grand scheme of criminal penalties and criminal laws, that's of course much less serious, than a felony or even a misdemeanor. But the point remains, we are still, as a legislature, still criminalizing this, and it sets a bad precedent, not only with regard to cannabis, but other issues as well. And who's to say, should House Bill 160 or the Senate version or something else pass with regard to this, that's not elevated up beyond a minor misdemeanor or changed in the future with regard to this. And just in sort of a global sense, I didn't mention this before, but I have to wonder if this has changed so significantly from issue 2 in the initiated statute process. I think it begs the question whether supporters will be back someday with a ballot initiative to do this, shut the legislature out entirely, and just say, look, we're putting this on the ballot as an initiative, and this is what how Ohio voters will vote, and then there won't be these conversations.
Thank you, Chair. Just another follow-up as well, Mr. Daniels. You covered in your testimony some of the sort of discrepancies in treatment versus alcohol versus marijuana. Can you elaborate why that is? Why is there such a difference in terms of treatment, in terms of someone sharing a piece of marijuana with another person? Why is there additional charges? And how does that compare to what other states are doing as well?
Through the chair to Representative Mohammed, there are perhaps other people here that can talk about how it's analogous or not to other states. As I often say, it's not a satisfactory answer, but I've got my hands full with Ohio, let alone what happens in other states. But what it's clear is this is treating things dramatically different than we do with regard to alcohol. The way it's written, the way it's framed, it seems like, okay, issue 2 passed, we're not happy about this. We're going to find ways around this by changing current law, again, in a way that Ohio voters didn't intend. And I think some of this also goes to just sort of the practical, real-world differences between the consumption of alcohol and the consumption of cannabis. So the idea that you can give somebody a sip of beer, or you can give them a bottle of wine for their birthday or something, but you can't go to like a Super Bowl party and share cannabis. I think for a lot of Ohioans, that just seems rather ridiculous.
Good. Representative Williams with a question.
Thank you, Mr. Chairman. So I'm going to try to do this as delicate as possible. I don't know if you were unaware or you were intentionally misleading, but I take it serious when we mislead members of the committee, and especially when we're on public television and we're misleading voters. So when you said that state statute for the social equity jobs program doesn't mention race, I don't know if you're not aware that it does, or you were intentionally deceiving the committee, because it's found in 3780.19 in section B2B1, where in order to be eligible for the program, a member must show, right, sufficient evidence that the business owner has membership in a racial minority group, right, or shows personal disadvantage due to color, or ethnic origin, or gender, or disability. These are the categories that I was mentioning earlier. So when you said that it didn't mention race, it made it seem like I was trying to lie. But I was being very truthful that the Social Equities and Jobs Program intentionally tried to give preferential treatment based on race, and the state of Ohio is not allowed to do that. And that's why not a single dollar from the program has ever been given out by the state of Ohio, because we can't follow what the voters voted in because it's unconstitutional.
Through the chair to Representative Williams, my mistake. Thank you for pointing that out. I did not realize race was in there specifically, and thank you for pointing it out on your iPad as well there. So I take full blame for not realizing it. It's never my intention to mislead the committee. That said, does that warrant throwing the entire thing overboard, or can we take that section of the revised code and take out the parts that say race or ethnic identity and continue on with the program? That would seem to me to take care of the concerns that you have.
Follow up?
Thank you, Chairman. So what we propose now is that we have a lot of programs that we fund in the budget. By giving a dedicated portion of taxes that we don't know what it's going to generate year to year, you're putting the state of Ohio in a position of just a pot of money that has to, by mandate, be expended on programs we don't know if they're successful or not, compared to bringing those funds into the general revenue fund where we do allocate them specifically towards those programs. So we've seen that. The state has invested more and more money into treatment, into rehabilitation, into recovery services. We've seen that time and time again. And there's other portions of this is unconstitutional as well. So the program in its entirety cannot be put into play right now by the state of Ohio because it's unworkable. But as soon as we try to touch any portion of that program, right, it seems as though the Republicans are racist because we want to remove race, when the program in itself had an unconstitutional racial intent that we're not allowed to do here in the state of Ohio, and there's clear precedent outlining that. So that's why there's a push to remove the program and start from scratch. And I'm more than willing to have conversations about what that should look like, whether it should be permanent line items in the budget for certain reentry programs that work towards helping offset some of the economic harm from those convictions in the past.
Through the chair to Representative Williams, I appreciate that, the opportunity for further dialogue and discussion about this. But when you talk about, well, we'll put this in the general revenue fund, we already fund addiction, treatment, we already fund this and that. I don't think anything is wrong with additional funding for that's even a little bit more targeted in the way that voters intended with the passage of issue 2. I don't think that Ohio right now has near the amount of, for instance, treatment funding that it needs. We remain up towards the top in this country of overdoses and overdose deaths. For the last at least 12 years here in Ohio, the #1 reason a person goes to an Ohio prison is for the crime of drug possession. We have a lot more to do in that regard, and of course the Social Equity and Jobs Program would also help fund and advocate for various legislation and enactment of legislation for the purposes of reform and other positive benefits, whether by legislation or otherwise, in a more sort of, comprehensive, holistic way, including, I'm sure, could be funding for some of the reform efforts that you support here in the legislature and put into bill form. So it's, again, we're at the point here where we're saying via House Bill 160, let's just toss it all overboard. I think we need to have these further discussions with regard to that, but House Bill 160 seems to be on a kind of rocket path through the legislature at this point.
Representative Callender with a question.
Thank you. Boy, these mics are really different than in the other committee room. It must have made way for the much greater seating capacity. Since we're going down the rabbit hole of the basically the level 3 and some of the other set-asides that were included in the now statutory language that was part of issue 2, and there has been some federal decisions and state decisions in the mediary time that would, in fact, as my learned colleague pointed out, that may strike those provisions of law as being unconstitutional. Your organization seems like it would be uniquely suited and within your traditional role to look to file a declaratory action to have a court declare whether or not those specific clauses have enough nexus to race to be legitimate versus the ones that the courts are throwing out. And it would be helpful to us as legislators and advocates to get an idea of where the courts would land on that, because that is going to be a point of contention. I think just as a fellow attorney, we're at a committee where everybody but one is an attorney, I think, so we're all thinking this, well, there's really strong legal arguments on both sides. Would your organization consider filing a DEC action fairly shortly, so maybe before this bill hits the floor or before conference committee, if there is one, we would all, as decision makers, as law writers, have that data so that we have an indication of where the courts may fall. And I think a lot of us in the room would like to know that answer, but we're not really in the position to file a DEC action, whereas your organization, I believe that's one of your mission statements and one of your founding principles.
Through the chair to Representative Callender, I have learned over the years never task our litigators with anything, with at least first talking with them about it first, so certainly don't want to do that here today. It brings up an interesting, whether the ACLU of Ohio or anyone, it brings up an interesting point, and one I have to say that I've never previously considered, and that is going to court for a declaratory action for legislation. So what you have is something that is not fully baked. It can change at any given time between now and its ultimate passage and enactment into law. So I don't know if you went in there, if a judge would say, look, this isn't ripe. This isn't ripe for consideration because you're just talking about legislation. Now, again, maybe that's happened in the past. I don't know. I'm unfamiliar with the idea of going in for a declaratory action judgment with regard to legislation. So, maybe that exists somewhere. I'm not sure, but it's an interesting thought.
Follow-up?
You would not go in for pending legislation. I think you're correct. That's questionable if it's right, but it's existing legislation. It's the current statute.
Right, I see.
And the legislation is looking at potentially changing that or eliminating that as a preventative action from having it thrown out later. So it's tied to it from a practical standpoint, but what you would be asking for a debt judgment on would be the existing statute as passed by the voters, as already in the Ohio Revised Code. You've got a code section to point to and say, this is what we need the declaratory action on. One of the reasons that you could justify is that the funds are currently being held basically in escrow and not distributed under the statute because they're waiting to see legislative or judicial outcome. So you've got the perfect ground and standing to file that action.
Through the chair to Representative County, you're absolutely right. It is more than legislation, of course. It's in current law. And it's something I'll talk over with regard to our litigators, this discussion that came up. Again, ACLU of Ohio is only one organization that could or would file such lawsuits to see what the courts think about this. So, it could be that someone else would do that. It could be that a legislator would do it, if they would be found to have standing to do so. So it's, I'll bring it back to our litigators and see what exactly they say about it. Of course, we could short circuit this entire thing by amending the bill so that current law is amended to take out those very specific race-based parts of the language, and then nobody needs to file a lawsuit anywhere.
Any further questions?
Let's assume that doesn't happen and act accordingly.
Seeing no further questions, thank you for your testimony.